My name is Michael Waddington, and I'm a court-martial defense attorney. In this video, I want to talk to you about sentencing proceedings in military court-martial cases. These proceedings are a little bit different than they are in the civilian side, both in the federal and state levels. One of the big things is you actually have a whole proceeding where you're allowed to call witnesses about your character. You're allowed to call witnesses to talk about mitigation, things that kind of minimize the offense and explain why it occurred. You can call good soldier, good sailor, good airman type witnesses, good Marine type witnesses, and you're able to present all these types of people along with your complete service record, letters of support. You can present a substantial amount of evidence to the judge or jury, depending on who's doing your sentencing, that can show you as a complete total person. In the military, the sentencing proceedings are based on this idea of rehabilitation. What that means is they look at your past, your present situation, your crimes, what's in the best interest of you, the military, and society. If you do it properly, you can present your client in a way that really humanizes that client, that shows their family struggles, whether they have PTSD from combat or from other things, and really show them as a total human. And the jury has to then go back, if it's a jury sentencing, and then they have to deliberate and vote on what sentence is really in the best interest of everyone, including you as the accused. So even if you get convicted of a crime, you can really make up a lot of ground in the sentencing proceedings. I'm talking about people that have been convicted of crimes that carry 50, 60 years. Going into sentencing, they could end up with a sentence of 20, 30 days or no jail time. These are just examples, but I'm just giving you one extreme. Or you can walk out of there with a reprimand or even no punishment if you do it right. On the other hand, if you have a lot of bad stuff in your background, if your crime is very egregious, then you're going to be on the higher end. But at a minimum, your lawyer should be presenting the evidence to show you as in the best light possible to try to get that sentence as far down as possible so that you don't go to jail for longer than necessary. The experience of the attorney and the credibility of the attorney makes a big difference when it comes to doing sentencing proceedings, both in front of the judge and the jury. And we give them reasons why a lower sentence is in the best interest of everyone involved, rather than just going up there with some emotional plea for mercy. Because military people don't really buy that, in my opinion. They want a reason. So for example, if you get convicted of stealing lots of money in BH or larceny or even a sexual assault, and you come in there and your lawyer explains your background, who you are, what you did, what you've done since then, explains the lack of prior convictions, and then explains what your plans are in the future to get out, to do this, to do that, and you can recognize your misconduct and then move forward with a concrete plan. The panel will often buy off and give you a sentence that's more in line with what the defense lawyers want versus the prosecution, who always wants some ridiculously excessive sentence.